pull out the book and take it out, that doesn't mean they own the book.
Okay. No, I know that, but the documents that she got and she gave me, could anybody get those documents?
You should have already had them, yes. Anybody here could download
Right,
them for you.
okay.
I think I showed Roger how to do it.
Yeah. No, I was just wondering, that's like the point I'm trying to make. Like, this lady's like, this is all I have. Well, and I said to the judge,
Yeah,
I said,
anybody could have gotten it.
right, and that's what I was trying to say, you know, like anyone can get that. That doesn't mean you own my property.
Correct.
You know, I need more proof than that.
Correct, that's right.
I guess the reason why is because I thought Lynn was just like a property management.
Well, but their name is on the deed. So they're obviously trying to, they're both getting contracts to manage, and they're now purchasing. So, and I don't know that means anything, because who knows whether they're the real people who put up the money. I have no idea. And that used to be what you had to do. It had to be the party that actually had the interest in the property. But they've wandered so far off the law, I don't even know what to say. All right, so I want to take folks through the Bailey decision here. Gwen, I sent you all of the decisions we're going to be looking at tonight, I think. So you've got... All right, so a court decision, starting from... Okay, good. We're on Bailey. So a court decision will always be between the plaintiff, that's the party bringing the case, and the defendant, so the person who's being sued. So names are always written this way, and in this case, it's Bank of New York Mellon, actually, as the trustee for some long trust, as, you know, blah, blah, blah. Bailey was the homeowner in this case. And this is after it was an eviction case that was decided in Boston Housing Court, went up to the appeals court, and then went over the appeals court to the SJC, the top court. So he's the homeowner, and New York Mellon is the bank, which bought back at the auction. And any case that you read, there will always be a summary at the top of what it is that they're discussing, and you'll see that here. Lori, do you want a copy of this so that you can look at it?
No.
You going to follow from over there?
I'm too lazy to make another copy. No, I'm fine.
Okay, you're going to stop me if it's not making sense, right? Even though you can't do it. Okay, so here they...
Can I ask you why would the Supreme Court on its own transfer the case?
So the SJC has been transferring cases. It's very unusual, but in this area of law, the courts have been so confused that they have grabbed a lot of cases. When they started grabbing in 2011, they have grabbed a lot. And the logic behind what they grab and what they don't grab is not always transparent to us. But in this case, this was a big one, because most of these cases, as folks know, even more so now than then, people are no longer suing the banks very much. They know to wait until after the foreclosure and make the banks carry the burden of the case. And so there were a lot of these already, and there have been even more since. The court basically got asked the question, does Casey Bailey had said, look, the foreclosure's invalid, they don't have a right to evict me. And so what the court got asked was, by the bank, was whether that was correct or not. Is that right? Or did Bailey appeal? No, Bailey must have appealed. The court ruled against him, and then he appealed. So that's why they picked up the case, and what they said was that Bailey was right, that Bank of New York was not the owner, here I have it highlighted, was not the owner because the sale was not in compliance with the foreclosure statute due to a defective notice, and therefore the deed was void. Now, I don't know, Jennifer, whether you'll capture the meaning of the word void or not. This is one of our big aces in the hole. Something can be illegal without it being void. Void means it's completely and totally illegal. It's so clearly illegal, it's as if it never happened. So when I use my example of I steal Mildred's car and I sell it to Janet, I never had ownership because it was stolen. It's a void act. So there's nothing I can ever do to make that not true. The car is still hers. I can never have ownership. So that act is legally void. Now, that doesn't mean that I didn't pretend I had ownership and I drove the car for 10 years and I sold it to Janet, and Janet sold it to Jennifer, and Jennifer sold it to Matthew. You know, all those things happened, but by law, none of them ever happened. It's as if time had stopped and those things never legally happened. So that's what void means. It means that legally it never occurred. So in reality, there may have been practical things that happened that made it seem like it occurred, but if it's void, the law stopped at the moment when the car got taken from Mildred to here. Everything after that never existed, according to the law. Now that doesn't mean you won't end up in court with something that's void, because Mildred gets the car back, and now I owe her for all the repairs on the car since you guys have all been driving it. I might have owed her for, you know, missed work hours, etc. I owe you because I sold you the car illegally. You owe her because you sold her the car illegally, and she owes Matthew because she sold Matthew. So a court might get involved, but there the court's not getting involved to decide who owns the car. They're making decisions to do restitution to all the parties who got harmed by what happened after the legally void act happened. So what the court is saying here is if Casey Bailey didn't get the legal notice the way he was supposed to get it, then everything after that was void. The deed, the foreclosure deed itself was void. It never happened legally, and everything after that never happened legally.
Do we know what the defect in the notice was?
Yes, he didn't receive the foreclosure sale notice. And the legal basis on which the court decided that was that he swore out an affidavit that he always gets his mail, has always gotten his mail, had gotten all the other mailings from the bank for the mortgage over the years, but didn't get that. So it wasn't like proof from the post office, it was literally his word in an affidavit. All right, so Bank of New York argued that the housing court lacked jurisdiction. So jurisdiction is the right for a court to make a decision, right? So if I'm going to argue that, well, say with my stolen car thing, right? Mildred wants to argue that I stole the car. She's going to be in criminal court or maybe in civil court about cars, but she's not going to be in housing court, right? She goes to housing court and says, please make Grace give me back my car. Housing court's going to be like, what are you doing here? We don't have authority over that. We don't have jurisdiction. So what the bank was saying is housing court doesn't decide title to land. It's not one of the things it does. Land court does that. Superior courts do that. Housing court doesn't do it. So even though Bailey's saying, look, first they got to prove they own the property, the bank is saying housing court doesn't have a right to decide who owns property. So he can't raise the issue here. No. The court agreed with Bailey. Well, what are we doing? You tell me. Why do we end up in housing court?
Because the bank takes us there.
Right. The bank takes you there, and the bank takes you there to evict, not to decide who owns the property, right? They just want to get rid of you. This is why you get your decision from housing court saying that the foreclosure is illegal, but the judge can't order them to give you the deed back because housing court can't decide the title. But they have to figure out enough about the title to know whether they can decide the possession.
You shut it off, Mildred? Seriously, just you can live without it.
No, I can't.
Well, it would be great if we can turn it off faster. So, yes, so they can't decide about the title, but if they haven't at least cleared their own conscience that the title is in the right hands, they can't possibly decide eviction. And that's what this case said. So the Bailey case is really important, and it's specifically where they said this. So, all right, I'm going to skip the background section, which is what all of this is. I would encourage folks who feel up to it to read through the background. The background section in these decisions is the facts. It's the story. And so by reading the story is often, for those of us who aren't lawyers, the way that you wrap your brain around the decision. So the question, as stated above, is whether in the course of a summary process action, so that's what eviction is, summary process, brought in housing court by a party acquiring the property pursuant to a foreclosure by sale, the judge may consider the former homeowner's defense that the plaintiff's title is invalid because the foreclosure was not conducted strictly according to the statute. So statute is another word for law. And so the answer to this question is informed by the historical context of the action for summary process. So in legal decisions, action means a court case. So they're asking here, they're saying the answer to the question of whether housing court has to look at title is informed by the historical context, so history, of the action for summary process. So what is the history of people bringing cases under summary process? What is the history of people bringing summary process cases? Well, I'm not going to read through all of this stuff about jurisdiction. But, for instance, here it says, the statute was revised in part so that all cases might be had as if the relationship of landlord and tenant had therefore existed between them. So these cases, although they're between you and the bank, is conceptually for the court between a landlord and a tenant. Right? That's the way they look at it. And that the purpose of summary process, which was legislation enacted in 1879, was specifically directed at those attempting to gain possession who had acquired property pursuant to a foreclosure of the mortgage by sale. So this is language that was put in specifically, and what it said was that it, quote, gave the process only to a person entitled to the premises, which required him to prove that he was entitled to the possession, and which said that the defendant should have judgment if the plaintiff failed to prove. Not your job to prove. If the plaintiff failed to prove his right to possession. So part of what the judge is getting wrong is she's saying, oh, you came in with the foreclosure deed. Okay, Jennifer, now you prove that they don't have a right to possession. Now, it is true that there's a presumption that if someone has a foreclosure deed that they own the property. Everybody assumes that. But the court's job is to actually look at the evidence. So there's been a confusion in the language, and given how late we started, I'm probably not going to walk us all the way through it, but there's been a confusion in the language that by producing the foreclosure deed, they kind of took care of their job. They didn't take care of that job. It's a starting place, and if you hadn't shown up in court, right, if you hadn't shown up, then the court would go ahead and assume they owned the property and give them possession.
Don't you think she should be here for this?
Oh, Corin?
Corin.
Oh, yeah.
Oh,
That'd be
yeah.
nice. Theophilus, too. Theophilus,
Yeah.
I think, is actually even farther off, because she doesn't seem to get it that there's even a question of ownership of the property.
Mm-hmm.
So she needs to read the Bailey decision. So,
So could you stick the Bailey decision in?
Janet read whole sections of the Bailey decision to Theophilus, I believe.
Yeah, she sure did.
To the judge,
And
Janet?
she tried to stop me
3 times.
Yeah.
So,
Wait, I'm almost done.
Well, that's a good
I have a little bit
idea.
more, 2 pages.
I'm almost done.
But the thing is, she wasn't even listening.
right, well, so this is a separate problem, which is the judge is not listening to us because we're not lawyers, right? But the law, I wanted Jennifer to see this, and I wanted you all to go through this, because when we were doing this originally, right, the banks were buying back at all of the auctions. We didn't have to worry about third-party purchasers, right? So we're now in a much more complicated legal situation where the judges seem to have lost their mind about the fact that it's still true. They have to own the damn property before they can evict somebody, and they have to prove it. So when they come in, I'll come back later to this issue of when they come in with only the foreclosure deed, but the reason I'm pointing this out is because this issue of them, the plaintiff failing to prove his right to possession, is the core issue. They have to prove that they have a right to even ask to evict somebody.
And this is all in here, Grace? Excuse
Yeah.
me? Okay.
Yeah. This
I'll
is
be
what we're
studying
looking at.
these.
Yep, and call with questions, because that's how you're going to get it.
Okay.
So, challenging a plaintiff's entitlement to possession has long been considered a valid defense in the summary process action for eviction, where the property was purchased at a foreclosure sale. I'm trying to remember, I don't think I was able to put my hand on New England Mutual Life Insurance v. Wing, but I do have it somewhere, so I don't think we printed it off today, because I don't think I could put my hand on it. But what it says is, in a summary process action, quote, by the purchaser at a mortgagee's sale, so mortgagee means the mortgage holder, The legal title may be put in issue. In other words, it can be debated. And therefore became incumbent upon the plaintiff to establish its right of possession to the land demanded. So if they're demanding the house, the land back from you, they have to establish their right to possess it. So now they're quoting, and you'll see this a lot in decisions, they quote a series of decisions, previous decisions. So that one was from 1906. And then we have Sheehan v. Dudley, which Sheehan Construction v. Dudley is hysterical, if I ever get a chance to explain to you the history for it. But I couldn't put my hand on this case either. I have the older case. This is a second decision that they made in this fight that was going back between Sheehan Construction and Dudley for a while. And this was the second decision in 1937. It said, in a summary process action available to purchaser at foreclosure sale, quote, it is incumbent upon such a purchaser to establish his right to possession. The legal title in those circumstances may plainly be put in issue. So the problem here is, in your case, there's a third-party purchaser, and the court's trying to say, oh, you can't challenge the title because they don't have the documents. There are no asterisks in here that say, oh, only if they have the documents.
Right.
This is what is the law. This is the history of the law. It doesn't matter if they have the documents. It's still their job. And in a lot of cases where there's a trust, was yours a trust or was yours Fannie or Freddie? Oh, no, you have a Freddie.
Yeah.
You have a Freddie Mac. Okay. So, but in cases where there's a trust, like in Janet's case, the other side has no right to say they can't have the documents. Janet pulled them off the Security and Exchange Commission website herself. She's not the bank. She didn't have a pooling and servicing agreement. It's in the public sphere. They can get their hands on it. And for them to only, I don't remember what they produced for you, whether it was just the foreclosure deed and the mortgage or something.
Yeah,
They didn't even bring in the assignments.
Right.
Those are all available at the Registry of Deeds. So they can't say they don't have more than what they gave you.
Okay.
And they actually, if you have it, if they want to prove something and you have the papers, they ask for discovery from you. So any papers you might have are available to them for this court case to prove their case, right?
Yeah.
So if they want to say, oh, well, we don't have the notices that should have been sent. We don't have those. We don't have the right to cure letter. We don't have the proof whether the loan modifications somebody asked for were completed properly, whether those application processes were ended with a turn-down letter properly or whatever. You hold all that evidence. That is available to them through discovery. And since it's their job to prove the case, they should have asked you for it.
Okay.
But they didn't ask you for discovery.
No,
yeah.
they didn't ask me for
They
anything.
punt, and then the judge says, oh, well, sorry, that's all they had. They couldn't prove the title because all they've got are these few documents. Well, that's not true. In a court case, if they have to prove their case, you ask for discovery from the other side. We do it all the time. It was their job to get from her what documents they needed. And if they ask for discovery from her and she doesn't have the documents, then they have a right to say to the judge, they weren't available. She can't disprove them because she doesn't have the documents, and we can't prove it because she doesn't have the documents. But that's what anybody would do, right? I steal your car, right? You don't have all the evidence. You're going to go into court and say, I want Grace to produce the bill of sale to Janet. And I want Janet to produce the bill of sale to Jennifer. And I want Jennifer to produce the bill of sale to Matthew. You have a right to ask for all of that. You're the plaintiff. You've got to prove your case. You can ask for all the documents you need if the other side has them. All right. So they refer here that they upheld this same...
What do you mean if the other side has them? Because they're claiming they don't have them.
No. We have them. Jennifer has them. They didn't ask discovery of Jennifer.
Oh. That's what the judge says. They don't have the documents.
Right, because they've chosen not to have them.
Right.
That doesn't change their legal burden, remains the same. They still have to prove title. And if they had to subpoena documents from the bank, right, this is what Janet tried to do, right, to defend herself. She tried to subpoena documents from the bank. Well, get them in person to come speak. But they can do that too, right? They could say, you know, Your Honor, we're the purchaser. We don't have those documents. And Jennifer says, Your Honor, but the bank does. They just go subpoena the documents from the bank.
Yeah.
Not your job.
Yeah.
Their job. This is their burden. They're the plaintiff. Okay. So they refer then back to a decision from 1960.
sorry, I think something.
There's 5 cops in a
Yeah,
meat
It's not
wagon.
our job. We're here, doing this. So they refer to a decision as recently as 1966. So this decision is 2011. So that tells you how long. They're reaching back, what is that, 45, 50
Person would have a heart
years.
attack.
Right. The purpose, yes, because it's more than 10 years ago.
You don't have
Yeah.
that 10
The
years.
purpose of summary process is to enable the holder of legal title, not somebody else. I can't just go, oh, I like that house. I think I'll kick that person out and take it. The holder of legal title to gain possession of premises wrongfully withheld, right? So if I can't prove I own the property, then you're not wrongfully withholding it, right? Because if I don't own it, I can't get it from you.
Right.
Okay. Right to possession must be shown, and legal title may be put in issue. Legal title is established in summary process by proof that the title was acquired strictly according to the power of sale provided in the mortgage, and that loan is subject to challenge. Now, this narrow, you can only challenge this, has been broadened by the SJC since. Okay. Then they talk again, they go back to whether housing court is the place where you're supposed to challenge this, and they go through the history of housing court. So, our conclusion that the housing court may consider the defense, this is the defense of challenging title, promotes the legislative goal of just, speedy, and inexpensive resolution of summary process cases. Now, you'll remember that the local judge has started trying to kick people out by using temporary restraining orders. This is the answer to that, which is that summary process is just, speedy, and inexpensive. They don't have a right to jump over to trying to kick people out by temporary restraining orders, because this is already what they call a remedy at law. And if there's a remedy at law, then you don't jump to equitable considerations. You deal with the remedy at law first.
Which is? the
Summary process. Right, exactly. The pursuit of speedy and ineffective summary process actions is compromised if the housing court must stay summary process proceedings while litigation on the validity of the foreclosure proceedings continues in another court, which was exactly what they were doing at this time. Schumacher was brought to court to be evicted. The judge said, Quorum said, I don't have jurisdiction. He held the case in housing court while he went to Superior Court and then land court. He finally gets his case lined up to argue it in land court. The Bailey decision comes down and says, no, housing court can't stay the proceedings and send it to another court. It has to be dealt with in housing court. The judge in land court gets up in front of Schumacher and says, Bailey decision, go back to Worcester Housing Court.
Oh, that sucks.
Yeah, it sucks. He's been all around the loop. His timing is just, he's always been on the wrong side of the curve. So this is precisely the type of unnecessary delay and inefficiency that the legislature intended to eliminate when it reorganized the trials courts, including the creation of housing court.
And how'd they do under 2015? Another effort on...
Well, that's going to be a different mess.
Yeah.
Having determined that the housing court has jurisdiction to decide Bailey's defense to the summary process action, we now address Bank of New York Mellon's contention that it nevertheless established possession. So I'm not going to spend much time on this because I got you through the legal part, but you'll see here it says Bank of New York Mellon had the burden of showing that there are no material facts in dispute regarding its title to property. The term material means something that actually matters. It's that meaning of the word material. So something that actually matters. You can't just say, well, the foreclosure was illegal because they sent the notice in a blue envelope instead of a brown envelope. It's not material. It has to be something that actually matters to what happened.
Now, did you get notices that this was going to happen?
What? What notices?
For the foreclosure?
Yes.
Yeah, they have their foreclosure notice. But you'll notice here that Bank of New York Mellon contends that without citing to relevant authority, like your friend Rachel said, that to meet its burden, it only has to prove that the foreclosure deed was recorded prior to service on Bailey of the notice to quit. And they say that, no, that's wrong. The plaintiff is required to make a prima facie showing that the deed to the issue, I know you don't want to hear that, the deed to the property at issue and that the deed and affidavit of sale show compliance with statutory foreclosure requirements and that it was recorded. So, that's where we get into trouble. This is this issue of they show up with a foreclosure deed and they say, this is enough.
Yeah, that's enough.
And it's not enough. So now we're gonna bang through a couple of other things. So a very recent decision was the Rosa decision, and the Rosa decision again specifically had to do with foreclosure, post-purported foreclosure eviction cases. And the only real issue here was whether you could bring counterclaims or not, and that's not what we're worried about in this situation. But what does matter is, hidden away in this very recent decision, is that the judge in the housing court had said, you can't bring counterclaims because you're trying to bring them under Mass General Laws, Chapter 239, Section 8A, which is the tenants, specifically tenants who pay rent, bona fide tenants, part of the law. And they say that that's wrong. And the reason they say it's wrong is what we care about here.
It's on that page number, so.
No, are you in the Rosa decision?
No.
Yeah, that's what I'm in right now. And I'm trying to find my little quote here. Anyway, the SJC says, well, you guys are talking about 239-8A that only affects real bona fide tenants, and the problem is because everybody's looking at the wrong part of the law. And they say instead, we've never had occasion to decide whether Section 8A precludes defenses and counterclaims in other types of summary process actions, of which there are at least 6, including post-foreclosure summary process actions. So what the SJC says is y'all are looking at the wrong section. You're looking at 8A, and what we are telling you is that for post-foreclosure summary process actions, you should be looking at Mass General Laws, Chapter 239, Section 1. That, needless to say, is the very beginning of that part of our laws, right? Chapter Section 1. So Section 1 is the beginning part of the law, and it has to do with all summary process cases. So 239.1 I don't have up here right now, and I'll send it to folks. I might be able to find it easily. Hold on a second. We're doing okay on time. Let me see. It'll all depend on how slow my computer is at the moment. 239, Section 1. Okay. So, 239, Section 1, what matters... Ooh, what did I just do? Oh, there we go. 239, Section 1. What matters about... This is the very beginning of the summary process law, as it's written into our laws. And you'll see, what's it called? For Gwen, who's not here, and Lori, who can't see it, someone want to read her what Section 1 is called?
I'm still trying to find where we are.
Somebody?
Persons entitled to summary process.
Can you hear Janet?
No.
Persons entitled to summary process.
So what does that mean? What does this chapter mean?
Standing.
Right, this is standing, but can somebody say, what does it mean for Jennifer, who hasn't done this before? What does it mean to say these are the persons entitled to summary process?
Because she has a right to prove, I mean, they have the burden to prove that they
That they are entitled to summary
correctly,
process.
yeah.
Right. The issue here is, this is the law that says who can walk into court and use summary process, the eviction law. Who can walk into court and use the eviction law? And the name of a law matters. This is telling you, this is the purpose of this law. So this is the first section of summary process, and so of course it starts out by saying, hey, who can use this law, right? Who can use it? And what they said in the Rosa decision was that there were 6 types of parties that have a right to use the summary process law. I'm trying to get this so that it fits the screen. Okay. And in their decision, they say there are 6 definitions. Now, when I count it, I count 7. But what they say is these are the different people. So if there's forcible entry onto land, if a peaceable entry has been made in possession is unlawfully held by force, that's foreclosure by entry, right? Peaceable. Sound familiar? Remember it from the certificates of entry? Anyway, the last one, the second to last one here is if a mortgage of land has been foreclosed by a sale under a power therein contained, and that means this power of sale contained in your mortgage. So paragraph 22 in your mortgage specifically says what they have to do to use the mortgage to foreclose by sale. If they can't use the foreclosure by sale, they have to either step on the property for entry or to take you to court. So it's only the mortgage that allows them to foreclose by sale, and they have to follow all the rules required. So this says
So
if
they either
these...
step on the lawn, the yard, peacefully.
That would be one option. They can take you to court, which none of them ever use. Although actually apparently they use it in Western Mass sometimes.
Take you to court for the
For
foreclosure?
the foreclosure, which is done in other states, right? A lot of states, they have to foreclose to the courts.
And then what was
But
the third
here,
one?
well, here they're allowed to, if a mortgage of land has been foreclosed by a sale under the power therein contained, in other words, under the sale, power of sale in the mortgage. And that's what we're going into court and saying, no. They did not foreclose the way the power of sale requires them to. And that's how they failed. So this is their threshold test. Do they get to go into court? Only if the mortgage of the land was foreclosed by the sale under the power of sale in the mortgage. If they didn't follow that, they didn't do it right, they don't have a right to even enter the court to fight for eviction. So the SJC referred to this very specific area, saying there are 6 ifs. As I said, I count 7. But in Rosa, they specifically say that there are 6 types, 6 ways, including post-foreclosure summary process actions, and they tell you as defined in Chapter 239, Section 1. Okay? So they specifically say, these are the people entitled to summary process, this is what they have to do it. They have to follow these rules. So, I'm going to go back to one last thing, which is this question of if they only show up with the foreclosure deed, is that enough? Another section that Janet tried to read out loud to the judge. Anyway, that's, you should have it in your pile there, Jennifer. It's the Bevilacqua decision. And hopefully I'm going to put my hands on it in a second. You should have it too, Gwen. I sent it to you.
Who's Gwen? Who's Gwen?
Gwen's on Skype.
Oh, okay. I thought she was talking to her imaginary
Yeah,
friend.
I'm talking to my imaginary friend again.
And you steal cars.
And I steal cars. There's all sorts of things you didn't know about me. You have met Gwen, yeah? A few times. She's been here. All right, so, oops. I don't know why it keeps doing that. Okay, so, Bevilacqua, so this was a different situation. Most of the decisions from the top court have come either from summary process cases, post-foreclosure eviction cases, or they've come from cases from land court that actually does decide title, right? That's one of the things that is the primary job of land court. So this was a land court case. This guy, Bevilacqua, took Rodriguez to court, and Bevilacqua was a third-party purchaser, okay? He was, in your case, he was Ream Property.
Mm-hmm.
And in your case, you're Rodriguez here.
Okay.
But in this case, Bevilacqua was the third-party purchaser, and Rodriguez was nowhere to be found. And so, whoa. Okay, that's interesting. So what happened was, here they're asked to determine whether a plaintiff, in this case Bevilacqua, who was the third-party purchaser, so they're still in the same situation that they are in housing court. It's the purchaser who's bringing the homeowner to court. So the question here is whether a plaintiff has standing, so that's, can they get over the threshold test for this case, to maintain a tri-title action. So here the question was, I'm the new purchaser, I'm asking whether I have title. That's what I'm going to court to do. That's what Bevilacqua was doing. He said, I'm the new purchaser, I need to know whether my title is clear or not. And I'm bringing the former homeowner to court to prove it. And he was in physical possession of the property, but his chain of title rested on a foreclosure sale that was conducted by someone other than the mortgagee, the mortgage holder. So Bevilacqua knew he had gotten title, but the sale had not been done by the party that had the mortgage. So would that have been a legal sale?
Nope.
No. So we actually already know the answer to this, but they got asked to please decide.